Well, my personal approach to litigation is that it depends on each case. It depends on each client. It depends on what their goals are. I think it's very important at the outset to establish with the client what are the goals? Are they reasonable? Can they be achieved economically? And that needs to be approached, addressed, figured out at the outset. Sometimes when a case is just beginning, you get so inundated with everything else about starting a case that you really, sometimes it's easy just to avoid and not deal with key issues like the objectives and can they be achieved in an economic way. We practice what we preach. We are in court. We are trying cases. And that's challenging these days. We have a practice, to be quite frank, of every trial we have, we are going to take an associate to that trial. We are going to expose that associate to that experience to help them develop, hone their craft. That's very difficult these days at many firms because it's not economic to do that. But we will take that associate or associates to a case and we will cover that cost ourselves to get them that experience. And so we have that policy in place, and every trial we've had, every arbitration we've had this year, there's been an associate there learning, gaining that experience so that the next generation can have the same level of skill as the partners.